Welcome everybody to another webinar with Dementia South Africa. Today we are very honoured to have with us Advocate Adam Brink, who practices as an advocate at the Cape Bar. He's previously a partner at Bissett's Attorneys and he's been a legal practitioner for over 20 years. Adam has so generously given of his time to Dementia SA many times to help us unpack and understand various legal aspects around dementia and curatorship, as well as what the law says around helping those that we care about. Adam, I'm going to hand over to you. And once Adam has finished chatting and going through some of the questions that we have, we are going to open up for a Q&A style. Thank you so much, everybody. Adam, over to you.
Abigail, thank you very much. Abigail, could you just indicate, can you hear me? Because if you can, everyone can.
I can absolutely hear you and I can see you. Thank you.
All right, perfect. Firstly, thank you for the opportunity to come and chat. It's good to see some familiar names, Karen Barachowitz and Minyoon Groenewald. We go back many years. And I've been asked to talk about curatorships. But to do that, I've first got to start by talking about powers of attorney. There's a lot of confusion out there, so I'm going to go through it relatively rigorously and fairly slowly, but there will be a chance to ask questions at the end, and I'll leave plenty of time for that. So don't worry that your question won't be answered if I don't get to it in the very first few paragraphs. The basic dividing line is whether you have mental capacity or don't have mental capacity. If I've got mental capacity, I can give somebody a power of attorney. So those of you who've bought or sold property will know that you didn't go down to the deeds office personally to transfer that property. You signed the power of attorney and some lawyer went down there with that power of attorney and acted for you. You may also have done a power of attorney at your bank. You might have been overseas for a while. You left a power of attorney with your brother-in-law. It's a very well understood concept in our law. We do it, however, quite differently to how the English do it. So in England, if you give somebody your power of attorney and then lose your mental capacity, your power of attorney continues. It's called an enduring power of attorney. We don't have that. So our legal system is Roman Dutch law because we used to be a Dutch colony. And the law relating to powers of attorney in this country goes back to the Dutch law. And in terms of the Dutch law, if you give somebody a power of attorney, it lapses the moment they lose their mental capacity. Now, if you're sitting there thinking that makes no sense, I mean, surely that's when you really need a power of attorney. I would agree with you. The English system is much better. Your main reason for executing a power of attorney is that when you lose your capacity, somebody can step in to help you. We've looked at this question for many years. In the early 1980s, the South African Law Commission, whose job is to make suggestions for the reform of the law, recommended that we should go over to a system of an enduring power of attorney. So the silly system that the power of attorney lapses the moment you need it should be washed away. And we should now have a system with checks and balances where if your power of attorney says it's meant to endure, it will endure. That was 20-odd years ago, sorry, 40 years ago, nearly 40 years ago. They recommended it, but it's never been brought into law. So we're stuck with the old system. So then the question arises, what does happen when you lose your mental capacity? Your power of attorney has disappeared. Your ability to make decisions and act disappears. So what is left? Instead of having an enduring power of attorney, we have a thing called the curatorship. So it's something that is even older than Dutch law. So in about 500 BC, so that's 2,500 years ago, the Romans enacted a series of laws that they called the 12 Tables, and they dealt with property rights and civil rights to a very limited degree, and marriage and so forth. And what they said is that certain people would have curators appointed to them. So the first category would be a prodigal, somebody who's wasting his assets. The Romans were very conservative, and they believed that people shouldn't be allowed to squander their wealth. And so if you were squandering your wealth, somebody would be appointed as your curator. People owning property who were minors would get a curator, and for the Romans, that was anyone under the age of 25. Women, because all women were regarded as minors, they would have curators, essentially. And then lastly, people who had gone insane. So if you went insane and you had property, a curator would be appointed for you. It would generally be an older brother or the head of your family, and that failing, the head of your tribe. That law of curatorship is essentially unchanged. We still do it exactly the same way 2,500 years later, except that we've added all sorts of procedural steps. And they're quite complicated. So we have uniform rules of court, which apply across all divisions in our country. And there's one of them, Rule 57, which says that if somebody has a mental disability or mental incapacity, they will have a court-appointed curator. You need a whole series of things before you can get a court-appointed curator. The first is that you need to prove to the court that the person involved is lacking in mental capacity. So that is generally done by 2 affidavits, one by a general practitioner and one by a psychiatrist. So just to use a concrete example, imagine that your mother has got deep dementia, so she has no mental capacity anymore. She's far down that road, but she's got assets. She has a house, she may have a pension, she may have shares, she needs them managed. Somebody will approach the court. So you would go to an attorney who would prepare an application, which is an affidavit for you to sign, to ask the court to assist. That affidavit would have those 2 affidavits by the doctor and the psychiatrist attached to it, and it would explain to the court what has gone wrong, why your mother cannot manage her own affairs. In your case, it would be dementia, but it could be a traumatic head injury. It could be that she's having a manic episode. It could be any of those things. The court will then appoint the first of 3 curators, a so-called curator ad litem. Ad litem just means the curator for this matter. And that will almost always be a junior advocate, somebody who's recently started practice. And what that advocate will do is that she will be the eyes and ears of the judge. So she will go and perform whatever investigations she thinks are necessary to discover whether or not this person does in fact need a curator. That will always mean going to interview the patient. So even if the patient is deeply demented and doesn't even know her own children, the advocate will go and ask the patient, do you need a curator? Do you know what your assets are? And so forth. And then that curator ad litem will make a recommendation to the court with regard to whether or not the person needs a curator. Firstly, she will recommend to the court whether you need a curator for your assets, and that's the so-called curator bonus, I'm going to say a little bit more about in a moment. And the second is whether you need a curator to your person, for yourself, your physical body, and that's the curator persona, the curator for your person. The first of those 2 that I mentioned was the curator bonus, and that is the person who is given charge of your living estate. It's a little bit like being the administrator of a deceased estate, because your job is to take control of the assets and manage them and make sure they're not lost. But it's even while you're alive. So the curator bonus takes charge of your assets and reports to the master of the High Court with regard to them. Now, the Master of the High Court is a functionary. She, in fact, because it's a woman at the moment, has an office in every major city where there's a High Court, and her job is to look after orphans and people under guardianship and people under curatorship and deceased estates. We'll talk about the master a little bit more in a moment. The second kind of curator that I mentioned is the curator personam. That's a curator to your person, and that person has powers and duties which are described by the court as being parental. So if you have a curator appointed to your person, that person has absolute control of your body. They can decide where you live. They can decide who is going to visit you. They can decide when and whether you need to consult with a medical practitioner. And Karen Barachowicz asked me a question earlier this morning. Would that curator have the power to decide whether or not you should have a COVID vaccine? The answer is yes. So they would have that complete power over you. They're not often appointed because, as you can imagine, that's an extraordinary invasion of what we regard as people's human rights. And it's only done in the most extreme cases where the social net has dropped that person, where they're being either abused or neglected. So going back to the curator bonus, that person's job is to manage your assets, and because he or she has to manage your assets, the master insists that they come up with security for your assets. So if you've got a house worth R1 million, because there's a possibility that that could be stolen from you by your own curator, the court requires, and the master requires, that you put up R1 million security. It's quite difficult finding that security unless you are a professional accountant or a professional attorney. So the master and the courts prefer to appoint attorneys and accountants to this job. It's neither a glamorous nor a remunerative role to take on. So if you're an attorney or an accountant, for the job of being somebody's curator bonus, you're entitled to 6% of the growth in their asset in a given year. So if the person's assets haven't grown at all, you don't get to charge anything. If the person's assets grow by 5%, which is what would happen if you put it in the bank, you then get 6% of that 5%. So it can work out being a very small amount of money. And it's most decidedly unglamorous. Every tiny little spending decision that you make has to be approved by the master before you do it. As an absurd example that I've seen it, a woman with dementia who wished to attend her granddaughter's wedding and needed a dress for the wedding had to get the master's approval to purchase the dress, and the master required there to be 3 competing quotations for the sale of the dress. You can imagine that this sort of granular, tiny, itty-bitty little administration can be most frustrating, in particular because you're dealing with the office of the master. The master's office has always been a bit slow, and at the moment they are disastrous. They can take months and months and months for the smallest of matters. I saw a matter recently in which 35 letters had gone unresponded to in one matter. It can be quite appalling. So that's what the curator bonus does, and that's what the curator personam does. So they have very different roles. The curator bonus looks after your assets. The curator ad personam looks after your body and makes physical decisions about you. But of course, the two things interact. If a curator personam were to decide on a very expensive course of therapy for which there was no money, then the curator bonus would essentially be able to stop it. Similarly, if the curator personam decided that they believed that you should reside in a particular home which was unaffordable, but the curator bonus said that there was no money for it, then they would presumably have to work together on that decision, and they may even come into conflict. That conflict does arise because very different people are appointed to be curator bonus and curator persona. You'll remember that I said that the curator persona has an almost parental, well, in fact, an explicitly parental role. The irony, though, is that the people most likely to be appointed as the curator persona are the patient's children. In particular, it tends to be daughters. So the person most likely to be appointed curator persona for a mother or a father tends to be one of their daughters. And they tend to bring very different emotions to bear on the curatorship. So the curator bonus is often a person who doesn't know the family at all and is a quite dispassionate dispenser of cash, whereas the curator persona is anything but dispassionate, and they ought to be passionate because their role is to ensure the physical well-being of someone to whom they're very deeply attached. So that sort of tension can arise. There is an alternative to the court-appointed curator bonus, which is that there is a provision in the Mental Health Care Act of 2002, which is really designed for very small estates. So if your monthly income is lower than 24,000 Rand, and if your total asset value, your gross, not net, your gross asset value is less than 200,000 Rand, then somebody on your behalf can apply directly to the master to have what is called an administrator appointed. The procedure for appointing that person can be extraordinarily lengthy. So even if the master's office is performing at its peak efficiency, which is always a pretty low bar, there are various time periods built into the Mental Health Act, which means that it takes a minimum of 190 calendar days for an administrator to be appointed. And if the patient involved is difficult and wishes to appeal and wishes to have the matter referred to a judge in chambers, that can extend itself to 338 ordinary days, calendar days, which, as you can see, is almost a year. Whereas the court-appointed process ought not to take longer than 2 months if the master's office renders a report in time, which is a big if. So those are the two ways to get somebody in charge of your estate if you've lost mental capacity. One is the one designed for very small estates, the administrator, very long process, and almost every estate I've ever encountered is larger than that. You don't have to own a lot to get above 200,000 Rand. And then there's the court-appointed process, which is a curator ad litem, somebody like me, advising the court on whether to appoint a curator bonus, who would be generally an attorney or an accountant, and perhaps also a curator persona, which would be a family member, generally a daughter. So those are the two ways to go about it. The advantage of the administrative process, if you've got a very small estate, is that it is free, so you can do it yourself. The disadvantage of the curatorship process is because it involves at least 2 lawyers, and probably 3. So you've got the person preparing the application, the person standing up in court to ask the curator ad litem to be appointed, and then the curator ad litem who must go and investigate and prepare a report for the court. That can be quite expensive. I've seen it going up to 40 or 50,000 Rand for such an application, which is a small amount of money for legal proceedings, but a large amount of money for something that you wish you didn't have to do. And if your estate is large, of course, it's not a huge amount. So the largest curatorship that has ever been in this city was the curatorship of the artist Vladimir Trechikov, who was worth hundreds of millions of rands. So the estate didn't feel it. But I think for an average pensioner, 40 or 50 is quite a lot. The good news is that the Law Society, or Legal Practice Council as they're now called, and the Bar Council both offer pro bono services, and you can sometimes get those sorts of pro bono services. So that's an introduction to the whole procedure. There's a slight wrinkle with regard to dementia in particular. So if somebody's been in a traumatic car crash and they are in a comatose state, it's perfectly plain that they need a curator. But the nature of slow onset adult dementia is that it can often be a little bit difficult to know when the point has been reached. So it will start with your parents becoming unable to remember where their car keys are, and it will end, if your parent lives that long, at a point where they don't know who you are or who they are. It's a long continuum, and it can take quite a while. At what point do you apply for that curatorship? My experience is that families tend to get along quite well by assisting the older person for quite a while. So although you're losing your mental capacity to some degree, you can be assisted by somebody else, and they can do that by using your bank card or going into the bank with you and doing things like that. And you can get along with that for quite a while until perhaps a bank manager intervenes and says, look, I think the point has been reached. Or where you have to manage investments and they require an affidavit, and the commissioner of that affidavit says, look, I'm not comfortable doing this. Or if a pension fund asks for a proof of life affidavit, that often is a trigger. Or if there's fighting in the family. So if you've got one sibling doing all the work and another sibling doing all the criticism, which is a traditional way for families to divide their labors, one doing the work, the other criticizing, then there will come a point where the person doing the work of managing the older person should, for their own protection, go about getting a curatorship. And where that point is reached is really a matter of intuition and judgment. Those are my introductory remarks, and what I would like to add to that is I would like to give you an opportunity to ask any question you want to ask. And just to get the ball rolling, I've been sent a question, which I'm going to find on my phone. It's a series of 4 questions. The first is a power of attorney legal and binding in South Africa? Yes, of course it is. If so, do I still need to apply for curatorship? The answer is yes. So once you lose your mental capacity, the power of attorney disappears. You have to apply. 2, who will appoint the curator bonus, curator personae, and curator ad litem? Or can anyone apply for any of these positions? The curator ad litem is appointed by the court to go and investigate, and then the curator bonus and the curator personae are appointed by the court after the curator ad litem has made his or her report. Can anyone do it? No. A curator ad litem has to be an advocate. It says so in the rules, because they're there to represent the judge. Can anyone be a curator bonus? In theory, yes. In practice, it has to be a professional, because non-professionals don't get insurance cover for the security that they must put up for the assets. Can anyone be a curator personae? No. To be a curator personae, you've either got to be a family member, or if there's no one able to do it within the family, it can be a professional, such as a social worker. So the classic example is the elderly lady whose children have predeceased her and whose husband has been dead for years. There, in consultation with the manager of the old age home, you would find a social worker who would come and assist. Thirdly, do I need to inform my husband's daughters when I am applying for the curator personae? Okay, so that would be an example where you, the wife, are applying for a curator personae to take over control of your husband's physical well-being. Do I have to inform his daughters? Yes, you do. So the court requires the curator ad litem to make all necessary inquiries one of the traditional roads that they've got to walk down is that they've got to look into what other family members have to say, and that necessarily involves children, if they're adult children. Then the last question is, do you recommend for every spouse, daughter, or son who's the primary caregiver of loved ones with dementia or any mental illness who is unable to do so him or herself to apply for a power of attorney? The answer is no, I don't recommend that, because if your mental capacity is absent, you then have the power of attorney is useless. I was sent another question, which I'm just going to have to find in my email, if you'll give me a moment. Right. Now, this is from a person who's already gone through a curator bonus process, and they'd like to know exactly how the curator's roles differentiate between the personae and the bonus. I think I've answered that. The personae deals with your physical well-being, making medical and other similar decisions. The bonus just deals with your assets. And here's a very interesting question. How much control does the curator bonus have over the finances? Say if the spouse who does not have mental capacity issues believes that they need a new vehicle, could the curator bonus say no, even if you knew there was enough money? The answer is the curator bonus has complete control over your assets. They can make that decision. They can say no, but it's subject to the master's approval. So if you write to the master and say he's being unreasonable, the master can overrule the curator bonus. Thirdly, I'm hoping the curator bonus would make some changes to some of my husband's savings, as I feel at least one investment is not doing well and should be transferred. Can I ask the curator to do that? That depends on what powers your curator bonus has been given by the court. If he's been given the power to manage investments, then he can do it. If he hasn't, then he can't. If you believe he should be given that power, you can then go back to court and get that power. Fourthly, if a spouse or child applies to be curator bonus, would they need to get security or a surety? The answer is yes. So unless the court exempts you from the requirement to provide security, you must provide it. I'm unaware of any case where a child has been exempted. There's good reason for that, which is that the person most likely to abuse an older person is the older person's child. It's the far and away the most likely abuser is children. It's a very expensive process getting security, and non-accountants and non-attorneys tend not to do it. Lastly, the question is, I'm just going to read it. Also not applicable to us as we've been through the process, but an important point to cover, I think, is the question of who is it best to have as a curator personae and who is a curator bonus. I think that's quite right. So the curator personae, it's a very important decision. It's parental powers, and there's nothing more important than that. Curator bonus manages the assets. Those are assets that could be stolen by the wrong person, and so that is quite important. She said the question asker says, in our case, our attorney advised that it would be better for the curator bonus not to be a family member. That's quite right. It's right for two reasons. The first is that it is astonishing the extent to which family members abuse older people's finances, and the hope is that a professional wouldn't do that. And secondly, the difficulty with appointing one family member as the curator bonus is that the other family members tend to be upset by it and to just cause a strife. I've never known it to work. Those are those questions. So those are the questions I've received, and I'm very happy now to answer any other questions anybody may have. Abigail, I'm not sure how it happens. Do people raise their hands? What do they do?
We have two questions that have come through on our chat.
Sure.
The one is,
I see them.
Okay.
Yes, I can see them. All right. So starting with the one from Karen Barochovitz. What happens when the family is completely fragmented and dislocated and disagree with the choice of curator personae and bonus? Is there an appeal process? Okay, so what happens is the curator ad litem is not a family member. They investigate by speaking to those family members, and they make a decision about who to recommend to the judge. It does happen that family members disagree entirely, completely. It's also, for want of a better way of putting it, the case that mental instability runs through families, and the mental difficulty may not lie only with the patient, it may lie with other family members simultaneously. It can be an extraordinarily hard business dealing with such families. But at the end of the day, the curator ad litem, the advocate, who's the eyes and ears of the court, has to make a decision about what recommendation to make. And he or she then makes that recommendation to the court in writing. That recommendation is distributed to all the family members. They can come to court. They can say whatever they wish to the judge. They don't have to oppose the application. They can just appear. And then the judge must make a decision. There is an appeal process. So any decision made by a judge that's not interim in nature can be appealed. And you could notionally appeal the matter all the way to the Constitutional Court. I've seen appeals to the Supreme Court of Appeal. It's a very sad thing. It's very seldom that a judge's decision is overturned. Kathy Miller asked the question, can a sane person give more than one power of attorney? E.g. for financial matters to one person and medical aid to another. Very good question. The answer is that yes, you can. So the sane person can give a power of attorney to, for example, their financial investment manager to manage their financial affairs. And you can give a different sort of power of attorney to another person with regard to medical issues. That is from the Health Act. So in terms of the Health Act, you can give what amounts to a power of attorney with regard to mental matters. So if you are, for example, in a car crash, or if you go into hospital for an operation which may go wrong, you can leave a power of attorney for someone to make decisions on your behalf. And in terms of the Health Act, the medical practitioners who are dealing with you have to have regard to it. So the normal one that people give is a instruction not to resuscitate. So that would be when you leave your own written instructions with regard to your medical care, just in case you aren't able to continue instructing, you're under anesthetic, you're in a coma, things like that. But secondly, you can mandate somebody else to make the decisions for you. You can say, I want my father, I want my son to make those decisions. The medical practitioners have to have regard to those written instructions. They have to have regard to the instructions by the person who's mandate, but it's not absolute. So if you can think of a silly example, a 21-year-old who rides a motorcycle and who says that if I ever lose the use of one of my legs, I don't want to be resuscitated. Now, I think most medical practitioners would say that's just absurd and would rather say, look, let's resuscitate him, and then he can make his decision for himself all over again, because that's just not a sensible sort of instruction. And given how insensible it is, it suggests that the mind was not applied to the written instruction in the first place. Secondly, of course, a mandate given to a child or given to a person who is him or herself insane would not be given effect to. So they've got to have regard to it, but they don't have to follow it if it's not sensible. I hope that answers that question. Lee, you just said please. I'm not sure what that means. Lynn
Adam,
said,
she's she said please clarify. Oh, you've
is
got
it clarified?
Okay.
Okay, it's clarified further down. Okay, I've got it. I'll get there in a moment. Right, en route, we've got Lynn. If one has a power of attorney and one's parent had mental capacity at the time, declining very slowly with time, how long is the power valid for? my parent would currently still know whether selling a property or changing an investment is a good or a bad decision. When does a power of attorney become invalid? It's a little bit like drawing the line between good and evil. It's impossible not to know precisely where the bright red line is between good and evil. But there comes a point when you know that something is definitively good or definitively evil. There's no good answer to your question, in other words. It's a matter of judgment. So if you think that your parent, as a result of a mental incapacity, understands investment decisions, but perhaps doesn't have the ability to carry them through, which is often the case with early dementia, then I think you would be entitled to continue relying on the power of attorney. If, however, they don't know what their assets are, don't know what a good decision is anymore, then I think you should stop relying on the power of attorney, if only to protect yourself. So if there's another sibling in the mix and there's likely to be some form of resentment, I think it'd be better just to get a curator. Lee Grayling said, please clarify whether it is both less than 24,000 and assets less than 200,000. You say 250,000. I have maybe it's increased, but the last time I looked it was 200,000. The answer is it says and. So if you are either earning more than 24,000 a month or have more than 200,000, then that's not what the administration is designed for. So it's either of those two. Karen's question, the lady's mom hasn't been diagnosed officially yet. What will the way forward be if she wants to sell her house that she still lives in? Her mom is showing signs of dementia, has not been diagnosed. For clarity, the mom wants to sell her house and she's showing signs of dementia and she is 93. The fact that you've got a clinical diagnosis isn't the answer. So the question is whether or not she has capacity. So it's often the case that people slip into dementia without it really being noticed. And the classic example is that is when you have two people who've been married together for a very long time, one of whom is getting dementia and the other isn't. What tends to happen is that the person without dementia starts compensating for the person who has dementia. So whereas before the wife would have done the shopping, now the husband will do the shopping. They tend to compensate and they tend to preserve one another's dignity in many ways by ensuring that those compensations are concealed. There's nothing evil in that. It's a perfectly natural thing to do. But what happens then when the husband dies is that the person who was being compensated for suddenly becomes very visibly unable to manage their finances. So even though there's been no clinical diagnosis, they certainly can't manage their affairs. And what you would then do is you'd have to move for a curatorship instead of transferring the house. But if the mother's simply showing signs of dementia, a little bit of forgetfulness here and there, understandable, age appropriate at 93, then as long as you're confident that she knows that what her assets are, that she does want to sell the house, that she understands the implications of it, then I think you can assist her with that. I would have no problem with that. Then a question from Chris. I have always had control of my wife's affairs. She has always asked me to sort out and give her assets, etc., for in case something happens to me. But what happens when she can't make any decisions? Again, this is a very common thing, especially for an older generation, that the financial affairs would have been entirely handled by one spouse or the other, often the husband. So what you would have is an older woman who had never managed the affairs, her own affairs, had never really wanted to, but she now got to the position where whether she wanted to or not, she can't. And the question is that given that she always had somebody else do it for her, given that she always wanted somebody else to do it for her, can Chris just continue doing it? The answer is no. So you would have to go to court and have a curator appointed, unfortunately. what your role in your wife's financial affairs suggests quite strongly, though, is that she would benefit from a curator, and it may also be one of those unusual cases where a husband can be appointed curator bonus with the exemption of security. So that sort of history of the wife having entrusted everything to the husband suggests that she was comfortable with it, suggests that you can be trusted with it, and suggests that security may be exempted in that case. I hope that answers that question. Abigail, have I missed any question?
No, thank you, Adam. And I'm not sure if, thank you so much. So incredibly informative. Your wealth of knowledge is amazing. And I know that everyone appreciates you sharing it.
That's a great pleasure.
I'd like to give everyone the opportunity, if they like. Karen has sent a message to say in the case of the 93-year-old, there's a son that, although of significant financial means, is pushing the mother to sell the house so that he can buy it. I think she was passing that on.
Okay, so I mean, just to talk about that, I think I've already mentioned that the person most likely to abuse an older person, regrettably, is a child. Also, there's a related phenomenon which is that children often do what they think is in the best wishes of their parents, but which also happens to run alongside what is in their own best interests as children. So in the case of an older person who's living in a house and is not really maintaining it, and that child is going to be inherited by the child, then it's in the interests of the child to sell the house before it falls apart. And it may also be in the interest of the older person to sell the house for the same reason. But the important thing to notice is that that's a conflict of interest. It's a conflict between your interest as a loyal child to ensure the best for your parent, and it's a conflict between your interest as a child to inherit more. And even if the child is of significant financial means, my practice is littered with people who look like they're of significant financial means but aren't. And it's also littered with people who, though they were of financial means, are not immune to a little bit of greed to have greater financial means. It's a recipe for disaster. It would be a much better, if there's any doubt about the mental capacity, it's a better idea to get a curator, would be my answer. Especially, as it says,
Adam,
to exclude the other siblings.
Thank you. So we've kind of come to the end of our session with you, but I'd like to give the opportunity while we're still recording, if anybody would like to ask Adam a question, please feel free to unmute yourself.
I don't know how many of you are familiar with this platform, but you can. There's a thing at the bottom called chat. So if you move your cursor on the screen, there's a thing called chat, and you tap on it and then you can type a message, or you may have a chat bar on the right where you can tap a message, or I think notionally you can put up your hand, although I can't see that on my board.
Sorry, the hand going up is if you scroll over reactions and you click on it, raise hand is there.
Okay.
I think, Adam, I think possibly everyone's a little bit shy and also maybe don't want to be recorded.
That's fine as well.
I'm going to stop recording.
All right, so Linda has asked a question and she says, what if there's no chance of conflict of interest and no family members have issues? If nobody's pushing for you to apply, must you still do it? The answer is it depends what you want to do. So if you want to assist the older person with managing her affairs, there comes a roadblock at a certain point. And so if you want to sell the property, at some point, that older person has to go into an attorney's office and sign an affidavit and sign a power of attorney to give that attorney the power to transfer the property. If the attorney is not convinced they've got mental capacity, then there you hit a roadblock. You can't transfer the property. Pension funds require proof of life affidavits over a certain age. So that means that your your parent has to go into an attorney's office or a bank manager's office and sign an affidavit, and the commissioner has to be sure that that person has mental capacity. And if you can't hide the dementia, then you're going to struggle. You're going to hit a roadblock. Also, just in general dealings with the bank, I personally have no difficulty with family members who are pure of heart for a while, using the PIN card on the bank card to draw cash, to buy toiletries and so forth. But there again, you hit a roadblock. Comes a point where you have to renew the credit card, you have to go in to sign for it. Bank tellers are trained to look for people who lack mental capacity. And it's quite obvious from the bank teller side of the counter when it's happening, because the person arrives with a child and the child does all the talking and the child says sign here and the older person looks confused, so that you reach a roadblock eventually. So even if there's no conflict of interest, and for there to be no conflict of interest, you would effectively not have to be not that person's child, because there's always a conflict. Even if there's no conflict, you should apply for it. Right, so a question for Karen. How do you as a carer record your wishes should you predecease your spouse? I'm not sure I understand the question, Karen. Do you want to just come on screen and ask it?
There we go. Sure. Hi, Adam.
Hello, Karen.
Hi there. So the question is that, say, for example, a spouse predeceases the person with dementia. How do you record what you would like to happen after going forward for that person with dementia? Okay. Where do you actually record the wishes for that person? So that's what my question is.
That's a very interesting question, and the reason the question arises at all is, you'll remember that I mentioned that the Health Act permits you. Sorry, let me start again. The Health Act requires medical practitioners to go through a shopping list of places to look for consent for a medical procedure. So the first place they have to look is the patient. They ask the patient. If the patient can't answer, they then move down the list. Has the patient left written instructions? Has the patient mandated somebody? Does the patient have a spouse? Does the patient have a parent? Does the patient have a child? But those are all living people. So medical practitioners have no requirements to consult the wishes of a spouse who's not living at the time that the question is being asked. So if you are the dead spouse of somebody with dementia, even though you were that person's carer, medical health practitioners don't have to take your views into account because you're not a living person. But they might do so nonetheless. So it's a very difficult decision to make as a medical practitioner, what care to give somebody when they can't tell you. So they may well look at the wishes of a dead spouse who was the carer of that person in life, but I've never heard of it being done, and I think it would be quite difficult to convince them to do it. Another question: if the 93-year-old mom sells her property, will her monthly SASSA pension fall away? That is a question to which I do not know the answer, I'm afraid. Does Carol? Carol has a question.
Yes, thank you. I'm one of those people who's been through the process. Another question I thought of is, what happens? So I'm legally appointed curator persona and our attorney curator bonus. What happens if one of us dies? Either me or the curator bonus. What happens then? Does the court then automatically appoint somebody else, or how does it work?
In fact, the master does. So the court has already done the heavy lifting of deciding whether a curator personae or bonus should be appointed. So if you die, or or no longer wish to do it, then the master can be approached to appoint another one. And in your case, you've got both curators, so whichever one is still alive would approach the master to make the fresh appointment. And I want to stress again, because I think it needs to be stressed, the dysfunctionality of the master's office. I've almost given up trying to explain to people how dysfunctional the master's office is at the moment. And it can be very frustrating for attorneys dealing with it. But that is the route to go. The master has the power. And sorry, just on the point, you don't have to die to stop being somebody's curator. So your attorney might retire. And if your attorney does retire, then he would resign his curatorship. And in that situation, the master would appoint a new curator bonus. And also the curator personnel, carer burnout is a very real phenomenon. It's a tough job. And it's hard enough doing all of the physical caring for somebody without all of the psychological burden of having to make difficult decisions. And so somebody in your position might at some point say, I just can't handle it anymore. Please appoint a social worker to help. And that does happen, and I've seen it before. So this part of your spouse role is not a till death us do part sort of thing. I hope that answers your question.
Yes, it does. Another quick one then is if our attorney retired, say, then would I have any say in I would like so and so to take his place, or is it up to the master to just make his own decision?
No. Look, it's always up to the master. Sorry, it's up to the judge in the first instance, and then it's up to the master in the second instance. But just because it's the master's decision to make doesn't mean that she mustn't consult with you. So the master is an administrative functionary. You have a right in terms of Section 33 of the Constitution to fair administrative action. And one of the key elements of fair administrative action is if an affected party is given a hearing before the decision is made, and you are an affected party. So it's your spouse, and you're the curator persona. So if you ask the master for a new curator bonus, you would actually do the running there. You would say, this is the attorney who says he's willing to do it. And unless that attorney has a history of stealing trust money, I think the master would go with it. So you have a big say.
Thank you very much.
Pleasure. I think we are starting to run out of time.
Yes, absolutely. And I'm just wanting to know, I'm sorry that my video is a little bit strange.
You look like an Andy Warhol painting.
Well, that's better than the real thing, I guess. Thanks, Adam. That's amazing that we've been able to have the session with you, Adam, because as I mentioned earlier on, it really is a grey area for a lot of families, and there's a lot of disinformation out there. And I think that you've been able to clear up a number of the real critical things that we need to discuss. I think the practical aspect of today's session, I think, is really what has been very, very helpful for everybody. And that's really what we're wanting to make sure that these webinars, reach the everyday issues that families face. Incredible wealth of knowledge and your very simple way of explaining and make. We really just are so grateful, Adam. Thank you very, very, very much. The other thing is that I'm wanting to suggest. Thank you. I'm wanting to also suggest, Adam, if there's any opportunity for the South African Law Reform Commission to look at the enduring power of attorney, we would be very interested in supporting that. Oh, I believe that I'm cutting in and out quite badly. So I'm going to put my video off. Let me just do that. Hold on 2 minutes. There we go. Maybe that will be a bit better. So if there is anything that we could do to support the South African Law Reform Commission on enduring powers of attorney, that would be great. And the second thing is that if there ever is an opportunity for Dementia SA to train magistrates, pardon me, and masters of the High Court, we would be very, very willing to explain what the process, what the disease process is in terms of dementia, and what makes the person cognitively unable to make decisions in terms of a disease process that is that is progressive and degenerative. So any opportunities that you can see for us to assist with any of the law societies around the country, we would be absolutely very willing to do that, because we know that it's a huge need.
Yes, that's a very good idea. You know, I think the people who need the training there are advocates, in fact. So certainly at the Cape Bar, we take in 20 or 30 young advocates every year, and they very rapidly become the people whose job it is to convince judges that this person with dementia needs a curator. So I think they would be the people who need that training, and I'm very happy to talk to you about that. I'm on the pupillage committee, so I could certainly arrange that.
That would be absolutely wonderful. Thank you so, so much. And once again, Advocate Adam Brink, thank you so, so much for availing yourself and for giving so much of yourself and of your time, both to families out there as a practicing advocate, as well as to us as Dementia SA. Thank you very, very much.